My light's off, but it's on. It works both ways. It works both ways, lights on and off.
Yeah, it was working both ways. I was tapping it.
Gotcha. All right, so we are going to start. So we will call the order.
Chair, we're not hearing you. Can you hit that button?
Try it again.
Okay?
Yeah.
It works both ways? Okay. All right, we're going to call the Flagler County Industrial Development Authority Board to order. It's October 21st. It's 1-ish, and we are now called to order. We will take a roll call. We have a quorum now. All right, so if we could all rise and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We'd like to now take a moment of silence to remember those of us in our first responders, and also a special note for our Deputy City Manager, Jorge Salinas, who left us tragically not too long ago. Okay, thank you. All right, before you have the meeting minutes from October 16th of the Industrial Development Authority. Were there any questions or comments to those meeting minutes?
Nope.
None on my end.
No questions.
Okay, seeing there are none, I'd like to have a motion to approve.
Second.
Motion to approve.
Second.
Second. We'll go with Richard and second with Chad. All in favor?
Aye.
Aye.
Any opposed? Seeing there are none, so moved. There are no financial reports, so we'll move forward. Before you also is a recommendation for the approval of the IDA bylaws. We went through these in our last meeting. There were some changes that we wanted to adopt, and those are recorded in the current bylaws in front of you. Is there anyone that has a question or a concern? All right.
No, sir.
Seeing there are none, we will have a motion to approve. I have a motion.
I'll make a motion to approve the
Ted,
bylaws, Mr.
thank
Chairman.
you. A second?
Second.
All right, Mr. Sean, thank you so much. All in favor?
Aye.
Aye.
Any opposed? So moved. Okay, we also have a question that needs to be put forth and adopted as the application fee for the IDA approved application fee. Any recommendations? I know that staff brought forward some recommendations that are current with other counties and what they're putting forth. Do we have any comments or questions?
Yes, Mr. Chairman. I would suggest looking into this and looking at the document that the staff provided there. My suggestion is that we start with our application fee on the $1,000 lower end, just as a way to kind of stimulate some growth here and as we get started. And we can always reconsider adjusting this up to the $1,500 mark, I think, at a later time. But if our neighbors are to the north of us are charging $1,000, and they have a pretty active IDA up at St. Johns County with quite a few issuance of bonds, I would recommend that we, since we're new and we're just starting to draw attention to the IDRB here, that we consider maybe the lower end on the application fee of $1,000 on that.
Okay, any other comments? Sean? No?
No, but I do agree with Sean on that. I think it should be lower.
Okay. So do we have a motion? Chad, you mentioned it, so if you'd like to make a motion.
Yeah, I would. I'll make a motion that we adopt a $1,000 application fee for our IDA applications.
Okay, we have a second?
Second.
Second. Richard, all in favor?
Aye.
Any opposed? So be it. All right, moving forward now, we have a staff report. One?
The staff report actually highlighted some more areas to support the justification of the $1,000 application. Like, for example, we looked at Lee County with between 0 and 5 million. They have an application fee of $1,500, and over 5 million, $2,500 application fee. St. John's had $1,000. Orange County, Seminole County, Volusia County, and Ocala County all had $1,500 for their application fee. So we're kind of right in that sweet spot in regards to our application fee for our county.
Wonderful.
And that concludes my report.
Thank you so much. Any questions?
I'd just add a comment and maybe something for future discussion is when it comes to these application fees, if we get to the point where we have a high volume like Lee County does, I think it is a good idea to have a structured application fee there because obviously over 5 million is going to require more work and more follow-up and more involvement from staff and us. So I think in the future, we should keep that on the table. And I also think we should consider what we want our minimum bond amount to be. And some counties have a minimum bond amount, generally around $2 million is the lowest they'll give because of the return on investment. So I'd like us to maybe talk about that in the future on if we want to establish a minimum bond amount up to the cap that statute allows. And my suggestion, looking at some of the other agencies, would be somewhere around $1 or $2 million. The different IDAs have different numbers for that, but something for us to consider is that we don't necessarily get tied up with too much of a lack of return on investment by issuing maybe $1 million bond or a $500,000 revenue bond. So that's just for future.
Okay. That's excuse. Let's put that under future business, and we can get some research on that to see what our other surrounding counties are looking at. Thank you for that, Chad. All right, future business, we'll add that to it. We have a IDA registration with the state of Florida. We're looking into the IDA brochure. And, Tuan, do we have anything else that we're working on in that regards?
For the IDA brochures, we're going to look at adding a QR code to expedite the process. So we're going to have a one-pager where anyone that's interested can scan the QR code and be able to access our application. And then just kind of highlight the step-by-step process and kind of a timeline of what that process looks like if someone is actually interested in the IDA.
Wonderful.
I've got a quick question on that, Mr. Chair, if I could.
Go ahead, absolutely.
Tywin, is that, I've been sort of dabbling with creating this brochure, similar to how we created some of the other documents and working on the logo, or I'm sorry, the seal. Is that something that you would like us, would you appreciate this, the help from us to sort of mirror what Lee County or some of our neighbors have done to tailor it to Flagler, or is that something specifically that you want
I've
county
already
staff?
organized one, so the next
Okay.
meeting, I'm going to have it and give you guys input and any changes or things you guys see need to be
Fantastic.
fit.
Okay.
That way we can get the process completed.
Very good. Thank you for that. I was
No
curious.
problem.
Thank you.
Good. All right, any department updates? Want anything any applications we're working on or coming through?
We have one application now that we have the application fee. We can present it to them because once that application completed, the fee need to be attached with it as well.
Wonderful. So our November meeting, we should have our
We should have our first application, depending on their timeline and returning all the material.
Fantastic.
Is that from Mr. Santori? Is that application not from Mr. Santori? Okay.
No.
And our next meeting is scheduled for November 18th at 1 p.m., correct? Any issues with that meeting date? Good. I think our other three members should be returning by then. Okay. All right, presentations. Our county attorney, Mr. Michael Rodriguez, it's your floor.
We're just trying to acquire the remote for the presentation. Are you going to be broadcasting from your? No, I'll use that one. That's fine. Very good. I can, as long as you stream it on this, it should be fine. So, all right. So that you can start the presentation. Yeah. All right. All right. Okay, the following is my basic refresher course on Florida's government and the Sunshine Law. I know that I was relayed some email communications that were done regarding how the Sunshine Law applies to this board. And there were some concerns that I read, and I think it's best that we clarify this. So this presentation is kind of a 30,000-foot view of the Sunshine Law and how it applies to a board such as your own. I like to make it interactive, so feel free to just ask questions and we can have it go as a back and forth. But basically, this is really going to be an overview of the law and how it applies to boards of the county. So the Sunshine Law basically derives its authority from both Article 1, Section 24 of the Florida Constitution, which provides that all meetings of any collegial public body of the executive branch of state government or any collegial public body of a county, municipality, school district, or special district at which official acts are to be taken or at which public business of such body is to be transacted or discussed shall be open and noticed to the public, and meetings of the legislature shall be open and noticed. Then it is codified in Florida statutes in Section 286.011, subsection 1. All meetings of any board or commission of any state agency or authority, or of any agency or authority of any county, municipal corporation, or political subdivision, except as otherwise provided in the Constitution, at which official acts are to be taken, are declared to be public meetings open to the public at all times. So under the requirements of the statute, there are three requirements. 1, the meetings of the public boards or commissions must be open to the public. 2, there must be reasonable notice of such meetings given. And 3, minutes of the meetings must be taken. Those are the three requirements in order for public meetings and public hearings under the Sunshine Law. So in regards to applicability, your board is governed, I've had to tweak this presentation to many other boards in the county, but your board is actually governed as an authority. You are a statutory authority that is created pursuant to Chapter 159 of Florida statutes. So you are a statutory authority, so that covers you as a commission and authority governed under state statute under the county. So you fall under that regards. The Sunshine Law also applies to private organizations that have been delegated public authority and are acting on behalf of the public with such authority that's been delegated to them. That doesn't necessarily mean that all private functions of a private entity, if they do business with a county or with a government, are subject to sunshine. Only those powers that were delegated to them by the public entity are those that are subject to the Sunshine Law. So, the law applies to meetings of 2 or more members of the same board or commission when discussing some matter which foreseeably will come before the board or commission. Therefore, the statute does not ordinarily apply to an individual member of the board or to public officials who are not board members. The Sunshine Law does not normally apply to a meeting of a member of a board with a private citizen. However, the courts of appeal, in the case of Jennings versus Dade County, held that such a meeting constitutes an ex parte meeting and that such a meeting raises a presumption that the contact was prejudicial to the decision-making process, which would require disclosure of such a meeting during a quasi-judicial meeting to overcome such a presumption. Now, the matters that come before you are not going to be quasi-judicial, so we won't have to overcome such a burden. But this does come into play, and I think this was the subject of the email that I read in which really want to parse the subject of what entails communications. So it's a fine line. If two board members are communicating, let's say via email, and you're communicating on anything, the communication in and of itself may not be violative of sunshine. However, when it comes to public matters and governmental matters, unfortunately, in the world that we live in today, perception is reality. And my advice to every governmental entity I've ever represented, every board that I provide counsel to, it is do not open yourselves up to such scrutiny from the public, because you open that door a crack, the public is going to burst through that door, and you will be embroiled in a controversy that, while you may be on the right side of the law, is a controversy that will drag you unnecessarily for no reason than if you were simply just, what I always tell someone, just don't do it. So heed my advice to limit your communications among board members solely to, when it comes to anything even closely related to business, that it be conducted at open meetings. If you are in social functions and you run into each other, I have no problems. Say hi to each other, talk about the weather, but keep the communications very brief, very social, and avoid any subject, because the law is that any matter which foreseeably may come before this board. So anything that even remotely even touches something that may, regarding the business of this board, that may foreseeably come, and it could be something that you might be remotely discussing something now that foreseeably could come before you 2 years from now. That is the potential of creating liability or creating a problem where one doesn't have to. And that's why I strongly caution to take the law seriously and advise you to really minimize any communications, especially written communications, either via email, via text, to those matters that are, one is just avoid it altogether, but also just be very careful between inter-board member communications so that you do not incidentally trip the sunshine law. I do this in my communications with the county commission. The county commissioners are fully aware of this, in order to even avoid inadvertent violations of the sunshine law. When I communicate with the county commissioners via email, and this is practical, my email is actually blind copied to all 5 of them, so that if one of them were to inadvertently hit reply all, the reply only comes to me, so that even under a wayward reply all will not violate the sunshine law. I mean, that's how seriously I take my written communications to multiple board members in order to stay straight of the sunshine law. So the sunshine law does not apply to a meeting between individuals who are members of different boards unless one or more of the individuals has been delegated to the authority to act on behalf of their board. Therefore, a member of a planning and zoning board may meet with an individual member of a city council to discuss a recommendation made by that board, since 2 or more members of the planning and zoning board are not present, provided that no delegation of decision-making authority has been made and neither member is acting as a liaison. So same applies to you. You may meet with a member of the county commission. That one-on-one meeting between you and a member of the county commission is not a violation of the sunshine law, because neither one of you are, you're both meeting separately. As long as neither one of you are acting as a liaison for another board member or another commissioner, there is no violation of the sunshine law. Or as long as neither one of you are delegated on behalf of another one, the meeting falls within the sunshine law, and there is no problems. So these are the meetings that are covered. So this is where the law will stretch out when we're outside of this duly noticed meeting. So, can a board member attend another board's meeting? The answer is yes. A board member may attend meetings of a second public board and comment on agenda items that may subsequently come before the commission for final action. However, it has been advised that if more than one board member is in attendance at such a meeting, no discussion or debate may take place among the commissioners on those issues. As an example, a county commissioner may attend a public community development board meeting held to consider a proposed county ordinance and express his or her views on the proposed ordinance, even though other county commissioners may be in attendance. However, the county commissioners in attendance may not engage in a discussion or debate amongst themselves because their discussions and deliberations on the proposed ordinance must occur at a duly noticed county commission meeting. So this is something that can be remedied, and it goes along this line, and I'll go through this slide, and then I can give you the remedies for this. So the other question is, can more than one board member attend a community forum sponsored by a private organization? Here, the answer again is yes. Meetings sponsored by private organizations are not subject to sunshine law unless the board members discuss issues coming before the board among themselves. However, caution should be exercised to avoid situations in which private political or community forums may be used to circumvent the statute's requirements. Recently, members of a city planning and zoning commission violated the sunshine law when they participated in discussions at meetings of a community improvement organization, which involved planning and zoning matters. In the case of the city of Bradenton Beach versus Metz, the court found that the commissioners' participation in the discussions was particularly troubling because they continued to attend despite sunshine law concerns expressed by the city attorney. If such a situation should arise, it is advisable to contact the county attorney's office for guidance. A remedy to such a situation would be to publicly notice the meeting, and a clerk would be in attendance to take minutes of the meeting for recording and therefore have such a community forum be conducted in the sunshine. So in a practical nature, and this has come to before me in other jurisdictions where I have represented the local government. If I have one or more elected officials or members of sunshine boards who are going to attend a meeting and they wish to openly discuss matters that may come before them for a decision, and it's at a meeting that's sponsored by a private entity, practical examples include homeowners associations, community forums, and they want to be able to openly discuss the matter without it being a violation of sunshine, they will then ask, can we now turn this private forum into a sunshine meeting? And the answer is yes. And to practically do that, it is quite simple. All it takes is for a notice to be published, and it's as simple as that notice is published on the local government's website, that this meeting of this community forum, Commissioner so-and-so and so-and-so may be in attendance and may discuss matters that may foreseeably come before the county commission or city council in a foreseeable future, and therefore, this meeting will take place on this date at this time. And then a representative of the clerk's office will be there to simply take minutes. Once that is done, it is now duly noticed. A representative from the clerk's office is there to take minutes. Now you've got a meeting in the sunshine, and those two commission members can freely and openly discuss any business that can go forward without violating sunshine. Now, the two of them cannot actually vote and officially bind the local government, but their discussions are now in the open and in the sunshine, and therefore they have not violated the law. And that is the remedy. So if there is an economic forum that is coming up, and you believe that more than one of you will be in attendance, and you wish to discuss a matter, feel free to contact the county attorney's office, and we can prepare a notice that two or more of members of the IDA will be in attendance at this economic forum. They wish to discuss a matter that may be of foreseeable importance to Flagler County, and then the matter will be noticed on our website, date and time. We'll have a representative of the clerk's office there to take minutes, and then you can freely discuss, you can openly deliberate, you can debate, you can discuss amongst yourselves, and it'll be a sunshine meeting. That will be duly noticed, and you will be able to exchange your thoughts and ideas without violating the law. And therefore, now you can turn a meeting that is outside of the scope of this meeting into a sunshine meeting without being in violation of Section 286. So this is the important, and this came up. So can a board member send an email or text message to another board member? My advice is no. Sunshine law requires boards to meet in public. Boards may not take action or engage in private discussions of board business via written correspondence, emails, text messages, or other electronic communications. This type of electronic communication also extends to comments on social media postings. The Attorney General's office has opined that members of a city board or commission may not engage on the city's Facebook page in an exchange or discussion of matters that foreseeably will come before the board or commission for official action. There are various cases that are out there. A lot of these then get intertwined in challenges to public records and public records litigation. And one of the reasons why I advise against such communication is, on a practical matter for you, for those of you on this authority, is I don't want to see any of you have to turn in your cell phones to the court for a judge to go through all of your text messages in camera in court, because they will. I've given examples to multiple local governments. One of the most egregious cases arose out of the city of Sunny Isles Beach down in Miami-Dade County. It was a city council meeting. It was a highly contentious city council meeting that dragged on. One of the city council members was seen on their cell phone, and it was obvious that they were texting. A resident was sitting in the audience, then demanded, I want to see that council member's cell phone. I want to see who that they're communicating with. I believe they're communicating outside of the sunshine. Communications turned out not to be a violation of the sunshine, but however, that council member had to turn in their personal cell phone. And then the tawdry contents of the text communications were made public. So half of the communications were simply her texting her husband that the meeting was running long and she was going to be late. The other communications were her saying how much of a bitch the mayor was and how she couldn't stand her fat ass. That became public. Again, to run foul of the risk of having all of your records, your personal emails, your personal texts, subject to in-camera court review is enough of an advice, probably enough of a chilling effect to seriously consider curbing any communications or any thought of communicating between board members through electronic media for matters that really don't need to be, don't have to have such a communication. This is matters that are best to be saved for open discussion and open deliberation at a meeting in order to avoid even the perception of violating the Sunshine Law and violating Section 286. So again, can a board member attend a social function if another board member will be in attendance? The answer is yes. Members of a public board are not prohibited from meeting together socially, provided that matters which may come before the board are not discussed at such gatherings. Therefore, a luncheon meeting held by a private organization for members of a public board at which there is no discussion among such officials on matters relating to public business would not be subject to Sunshine Law merely because of the presence of two or more members of a covered board or commission. Similar, as we discussed, more than two of you can attend as long as you do not discuss any official business. If you reasonably foresee that business may be discussed and you wish to discuss it, let the county attorney's office know, and we will try to perhaps make such a meeting a sunshine meeting by simply noticing it. So these are the procedures for public meetings. So and as we hold them in, and our staff here does a really good job of preparing the agenda in order for these procedures to be kept. So the Sunshine Law does not mandate that a board provide notice of each item to be discussed via a published agenda. The Sunshine Law does not require a board to consider only those matters on a published agenda. Even though the Sunshine Law does not prohibit a board from adding topics to the agenda of a regularly noticed meeting, the Attorney General's office has advised boards to postpone formal action on any added items that are controversial. So you're not bound by the agenda, but if you discuss an item that may come up at the open meeting, you may add it to the agenda or add it for discussion. It's just advised that if it is something that is highly contentious, that it is best to give the public an opportunity to render their opinion or to discuss it, that it be then moved to the next, to another meeting. But if it's really something that's pro forma, that you can discuss it and it's not on the agenda, if it's brought up, it's discussed at the open meeting, you may still be able to vote on it, even though if it's not on the agenda. That's not a requirement under the Sunshine Law. The Sunshine Law does require that minutes of a meeting of a public board or commission be promptly recorded and open to public inspection. Now, the term minutes contemplates a brief summary or a series of brief notes or memoranda reflecting the events of the meeting. Accordingly, a verbatim transcript is not required. So we don't need a court reporter giving us a full transcript of the meetings. The minutes it's a brief summary. So under notice, the reasonable public notice is required for all meetings subject to the Sunshine Law and is required even though a quorum is not present. The Sunshine Law does not define what reasonable notice is. The type of notice given depends on the purpose for the notice, the character of the event about which the notice is given, and the nature of the rights to be affected. In each case, an agency must give notice at such time and in such a manner as to enable the media and the general public to attend the meeting. And then when it comes to public comment, the Sunshine Law now mandates that members of the public shall be given a reasonable opportunity to a board or commission. The opportunity to be heard does not have to occur at the same meeting at which the board takes official action if the opportunity occurs at a meeting that is during the decision-making process and is within a reasonable proximity in time before the meeting at which the board or commission takes the official action. The Sunshine Law does not prohibit the board from maintaining orderly conduct or proper decorum in public meetings. Don't really foresee that being too much of an issue at this meeting, but it has been a rash of concern, at least throughout the state of Florida, when it comes to the issue of public comments, especially in some jurisdictions where we have the sections in public meetings where we have public comments on matters that are not on the agenda. The courts have opined that the Sunshine Law does give the public a right to provide comment on matters that are being discussed and up for vote. So that would be agenda matters, and that there is that you do provide comment for those actions that are going to be voted upon. So the general public comment on matters not on the agenda, which in some local jurisdictions has become, unfortunately, circus time. It's been a time for folks to generate content to increase the number of clicks on their social media pages. I have been in jurisdictions where the cameras have been shut off during public comment time with the idea that it was mainly because folks just got up there and decided they wanted to curse out their city council members. Or they were using one of the things I always thought it was not the role of the local government to subsidize your media empire. If you wanted to videotape something for placement on your social media page, then you tape it yourself and not use the local government's feed to provide your media content. There's been pushback, but there is no. There still has to be a recording. I mean, a lot of these cities, they just turned off the cameras. There was still audio recording. There was still a transcript of the public comments, but the video recordings were shut off in order to minimize what was turning into a spectacle when it came to public comment. So that's been the most contentious aspect. And then when it's coming to the rules of orderly and proper decorum, there's a balancing act between how much you can rule for public decorum and then also not infringe on a speaker's First Amendment rights. And right now, one of the leading cases did come out of Brevard County, and it was the Brevard County School Board versus Moms for Liberty, in which there was the Brevard County School Board had rules. Many local governments have rules that you cannot either directly address a specific commissioner or make disparaging comments about a specific commissioner. So there were questions whether that was regulating a speaker's content instead of it just simply being what was not necessarily regulating the speaker's content, but does Was it a subject matter regulation, or was it kind of a subjective regulation as opposed to an objective regulation, where you can objectively regulate obscenity, but then are you then subjectively regulating the topic because one elected official disagrees with the position of the speaker, but allows another speaker to speak because they agreed with that position, and that's impermissible restraint on speech. So that's the jurisprudence that the courts are battling when it comes to the nature of public comment. So that was along the same lines there. So when it comes to voting, so a member of a board who is present at a meeting is prohibited from abstaining from voting except as authorized by statute. Legal reasons for abstaining are an actual or the appearance of a possible conflict of interest which would inure to the board members special private gain or loss, which they know would inure to the special private gain or loss of any principal by whom they are retained, or to the parent organization or subsidiary of a corporate principal by which they are retained, other than the public agency as defined, or which they know would inure to the special private gain or loss of a relative or business associate of the public officer. So there's no such thing in Florida if you are a board member or officer who has a vote for abstaining by conscience. If you are there and it comes to the vote, you must vote unless you have a conflict of interest, and it's a financial conflict of interest. Either you are going to have a special private gain or loss as a principal, or as a relative or business associate of the principal, or the third, I just forgot the third one, sorry. Or if you are retained by the principal. Those are the only three reasons where you can abstain from a vote. And when you elect to abstain, you must then fill out the form that is then submitted to the Commission on Ethics with your reason for abstaining, as well as then you must then disclose what the conflict of interest is and what is that special private gain or loss. So these are the remedies and penalties for violations of the Sunshine Law. So there are criminal penalties. A knowing violation of the Sunshine Law is a misdemeanor of the second degree, and conviction may result in a term of imprisonment not to exceed 60 days or a fine of up to $500. There's also removal from office. If convicted, an officer can be removed from office by executive order of the governor. An officer who pleads no contest is deemed to have been convicted. There's also non-criminal infractions. So a public officer found violating the Sunshine Law is guilty of a non-criminal infraction, punishable by a fine not exceeding $500. And there are reasonable attorney's fees will be assessed against a board found to have violated the Sunshine Law. So, and that's it. So that is the 30,000-foot view of the Sunshine Law when it comes to your basic understanding of the law. So what I always advise, the easiest advice is, be careful. I always just tell everyone, if you think, can I do this? Most times, just don't. If you have any doubts, the first thing you should do is contact the county attorney's office. And we're happy, all three of us in our office will gladly pick up the phone and guide you through any issues in regards to Sunshine. And we're all well-trained, well-versed in the law. Pretty much any government lawyer in Florida is well-trained and well-versed in the law to help you through the process and to make sure that you do not run afoul of the law. I mean, Florida has probably one of the most stringent open government laws. It's the main reason why the internet meme and the joke of Florida Man exists. It exists because of the Sunshine Law and our open public records law. Because every single freaky thing that happens in the state of Florida, the press can get a hold of it within probably 5 minutes of it happening, because all of our records are laid bare for everybody to see. And that's why Florida Man exists. That's why you don't hear about Pennsylvania Man or Indiana Man. You always hear about Florida Man. It's because of the Sunshine Law and our public records law. So if you have any questions, I'm free to answer them or even go over some just bad war stories or bad histories.
Thank you for the in-depth definitions. Very much appreciated. Any questions from board?
I have a couple, yes.
Chad, please.
Thanks, sir. I just wanted to ask you about the spontaneous meeting, the scenario where there was either a conference or an economic development forum of sorts. Is it required that we have a representative of the clerk, or can we take our own meetings? And is there a requirement for it to be recorded?
Well, there's no requirement for it to record it. However, by spontaneous, if you haven't notified the county attorney's office or the county, then it hasn't been noticed. So
wasn't the
because
best-
it hasn't been noticed, now it's too late. Now in order for, if there's no notice, it doesn't matter if there's a clerk there to record it or not. The first step for it to be a sunshine meeting requires that there be a notice, that it be a
Scratch
published notice.
I'm sorry, scratch spontaneous from that. If there were a conference where we were in attendance, not spontaneous, we did properly notice it, can we take our own meetings?
If it's noticed, if we go through the process of noticing it, we will have a member of the clerk's, a representative of the clerk's office there to take the minutes.
Even if it involves traveling or
Yes.
with this particular, okay, understood. Next question I have for you is on your slide about email or text messages, it mentioned private discussions on there in the electronic form. Not that this would apply to us, but I'm kind of curious on it. Does it involve social media groups? Say a private social media group is created to complain about a new economic project in Flagler County in which some members are commenting back and forth.
Yes. It's happened to City Coral Gables. There was a contentious matter. So here's the fine line. A matter is discussed on a social media page. One commissioner writes a comment. Another commissioner writes a comment. There are two separate comments, like two ships passing in the night, not necessarily a violation of sunshine. It would be like being in a meeting, two commissioners speak on a topic, they're not deliberating. Now, social media post, there's a comment. One commissioner comments to a matter. Another commissioner hits the reply button, replies to that commissioner's comment. By replying to it, now we have a violation of the Sunshine Law, because now you have one-on-one communication electronically between two commissioners, and that social media post, even though it's public, even though everyone can see it, it's not noticed, and there's no minutes. Further, I'd state it's not even a public record because it's not held, it's not archived by the local government, which causes all sorts of problems. But now we're outside of sunshine, we're more in the public records notice problem. But, and that happened with the City of Coral Gables. We had two commissioners were basically arguing between each other on a Facebook comment section.
Wow.
And it turns out that they were found in violation of the Sunshine Law.
Yeah, wow. Thank you for that. And legal representation, if a complaint is made and it involves the board as a whole or an individual member, and we go down some of the paths of the remedies and consequence that you talked about, is it pretty much on us to self-represent, or do we fall under some liability factor of the counties?
It's going to depend on the action. That I will have to. That's going to depend. I need to look into that because there's certain aspects where it's going to now be individual action.
Right.
And at that point, because the county attorney's office's obligation is to the collegial board and not to the individual member, and if there's individual liability, then representation would be the individual member's responsibility. It would be similar to what has been held. I haven't seen it held in the context of sunshine law violations, but when it comes to ethics violations, in ethics violations, the local government attorney can only represent an individual commissioner or council member before the ethics board, but only if the entire board as a collegial body takes a vote to waive the conflict of interest to allow the government attorney to represent the individual board member before the ethics commission. So it would be the same here because my legal obligation is to the board as a whole and not to an individual. Representing an individual on an issue that may affect the entire board may present itself as a conflict of interest.
Okay, thank you for that. And my last question for you, sir, is could you just provide any advice regarding what we do with interacting with large corporations sometimes or industry participants locally? Any advice when we meet regarding ex parte communications or being upfront, revealing any conversations or prospects, anything we need to know from what we do legally to avoid an issue?
No, your ex parte communications are fine because none of the matters that come before you are coming for you to render a decision on a quasi-judicial matter, on a quasi-judicial basis.
Okay.
So you are not, you're not sitting as a board, planning and zoning boards, code enforcement boards, county commissions sometimes when they render decisions, when they sit as in a quasi-judicial matter, they have to do, they're basically the triers of fact, and then they have to apply, and, make conclusions of law. You're not doing that. You're simply receiving information, making recommendations on a decision. So your decisions are not quasi-judicial. So there is no, plus ex parte communications in and of themselves, even in a quasi-judicial nature, are not illegal.
Right.
They only carry a presumption of impropriety.
Right.
And the requirement that they be disclosed is only to overcome that presumption. But there's nothing in and of themselves illegal.
Okay.
So any communications that you may have, you disclose, yes, I'm a member of the IDA, and this is where, and disclose your business, your interests. But it's not going to affect the decision itself because your decision is not being based is not in a quasi-judicial forum.
I got it. Yeah, mine was more along the lines of maybe like a practical example of somebody that formerly had a business relationship with a large hotel chain or another company that was applying for a revenue bond that we would be voting on, or a family friend that you have vacations with that has a construction company who's applying for a revenue bond. Is that something legally we are required to disclose?
At that point, then you're going to want to then determine whether you fall within that three criteria that I provided to you, whether you then have a legal conflict of interest that would require you to abstain from voting.
Okay.
And that is, are you obtaining either a special pecuniary financial gain or loss due to your relation, either as a principal, as a relative, or as an agent of the applicant.
Understand.
And if you fall under those three categories, then you have to disclose that relationship.
Okay.
Then you abstain from your vote, and then you file that relationship as part of your form that gets filed with the Commission on Ethics.
Very good. Thank you, sir. I appreciate that.
No
Thank
problem.
you, Sean, anything?
Nope, no questions.
No, thank you.
No questions.
I have a couple. The key word there is, in what I always followed in previous positions, was perception. That if you look at the perception, then that should give you a green light or a stop. So I completely concur and agree with you on that. Chad's question was brought up about legal representation. That was brought up at a previous meeting that we had a few months ago. Could you look a little deeper to make sure that if an individual violates a sunshine law, that they're on their own, or they do have that? And I understood what you said, it could be the board completely, but could we get a firm, unless you
Yes,
feel?
I will confirm, but I think it might still be in the same context as ethics violations, but I will confirm whether that holds also for sunshine law violations.
Thank you. Just because we're missing 3 board members, I want to make sure that they
Right.
hear.
I'll prepare it as a memorandum and submit it to you through staff.
Wonderful, thank you. In regards to open meetings, if a board member or two are not available in person, could they be represented via Zoom?
Okay, there is no prohibition against that. So the state law requires that if there's going to be remote attendance at a meeting, that the requirement is that there be a physical quorum at the meeting site in order for the meeting to go forward. And then those members that are not in attendance who can attend electronically may do so. Okay. So you cannot have 3 physical members and 2 attending via Zoom, then you can't have a meeting. I think that was what was then, that was the case before COVID. I know after COVID, there were some revisions, and I think once that subsided, we returned back to the requirements that there can be remote attendance as long as a physical quorum is present at the meeting site.
Okay, thank you. In regards to the oath of office, we fall underneath that jurisdiction of Section 286 for the oath of office.
Actually, you fall under the section that chapter 159, which is
Right.
the IDA section, provides that you, as an officer, takes the oath of office that is the constitutional oath of office. And I know I submitted as part of a memorandum in answering some of the questions that you presented. The memorandum had in the back as an exhibit the actual oath of office for you guys to fill out,
Right.
sign, and notarize.
Yes.
That's the oath of office.
Gotcha. And that's been done by understanding. Are there any other authorities or boards that the Board of Commissioners have set forth for the county required to do the oath of office besides this IDA board?
Off the top of my head, I don't know. I know that, but the IDA has that because it's specifically enumerated in Chapter 159.
Gotcha. So that's another question I'd have to find out. I want to make sure we're covered
Right.
as a county, that we're doing it, because this was it seemed to be a little bit of a surprise.
Right. There are other instances, and the law states if there are certain volunteer boards or those that are not paid, and you do not receive any pay from a local government, you are not required to take an oath, basically an oath. So volunteer boards, there is an Attorney General's opinion which states that volunteer boards are not required to sign an oath, like employees who receive money. Like I had to sign an oath to become, as county attorney. Because this board has the statutory requirement under 159, then that falls, as well as the constitutional requirement for the county commissioners or city council members to have an oath of office, that falls under. But there are some other volunteer boards which are exempt, and therefore then it just becomes optional, and whether they have to enter into an oath of office or not as volunteers. So the only requirement for an oath is if you do receive pay from the state of Florida, then you are required to sign an oath.
Right. But we do not fall under that criteria.
You do not fall under that one. You fall under the specific authority of 159 that requires that members of an IDA must sign the constitutional oath of office. And that's the oath that I provided you all to
Michael,
execute.
thank you for that, because, again, that was kind of a surprise. We sort of felt that way, but we wanted to make sure, and you answered our question, so we fulfilled that obligation. Again, I'd love for you to please look
I will.
throughout. Thank you so much on that. And then my last question, I have two more. Subgroups within the board. If we have two members that are going to work on a specific project, that has to fall under sunshine because there's two.
Yes, if you're going to create a subgroup of board members, yes, and they're going to meet. It's going to be a sub.
And it may be something that comes before us as a vote that even gives you the second check mark of sunshine.
Yes.
Wonderful, thank you. And my last question is, how does staff fall under sunshine?
They do not. So meetings of staff meetings are not subject to sunshine. Also, any committees that are delegated or created by a local government for the purposes of fact-finding are also not subject to the sunshine law. Or volunteers that are gathered, groups that are gathered for those purposes, as long as they do not have decision-making authority, are not subject to the sunshine law. And also individual board members who meet with a staff member, those meetings are not subject to sunshine law.
No daisy chain application, one to the next.
No, well, again, that would be creating, you can't create a liaison. So you cannot use a staff member as an intermediary to provide communications between board members.
Gotcha.
That would be a violation of the sunshine law.
Understood. Okay. You've cleared it up for me. Thank you so much. Those two areas. Thank you so much. Anybody else?
Oh, that's good.
Good, good, okay. Michael, anything else you'd like to add? That was fantastic.
No, I think you've heard enough from me.
I appreciate it. Thank you so much. Okay, we next move on to one. First of all, want to apologize. Last meeting, when you were introduced, I didn't feel it was done in a manner to which I was comfortable with, and I think the board would want a redo, kind of reverse. So welcome, and thank you for all your work already this last month. You've made a tremendous impact. And so I'd like to give you the opportunity to really shine and tell us, because you have an impressive resume and education basis, and we're thrilled to have you. And would love for you to expand a little more on that, if you would.
Sure. As I mentioned, my name is Tawan Arrington. I'm a native of Laurel, Mississippi. I have a undergrad degree in agricultural economics from Alcorn State University. I received a master's in economic development from the University of Southern Mississippi. I've actually completed the Jobs EQ certification. That's a certification a lot of economic developments or EDO organization use to get community data to really tell a story about their community. I've actually had a certification from the University of Wisconsin in cooperative development. Did some graduate work at the University of Arkansas, some certification at the University of South Florida, and I even obtained some economic development courses at Harvard University. I'm currently a member of the United Way Board for Flagler, Volusia. I'm a member of the Rotary of Daytona Beach, former member, and also attended the leadership classes in Daytona Beach area. I'm currently a member of the International Economic Development Organization, the IEDC, and in 2005 and 2009, I ran for mayor for the city of Amory. And next, some of my career highlights. I previously worked for Team Volusia, where we did about 30 trade shows advertising and highlighting Volusia County. We actually participated and became the 81st certified economic development organization. Out of 5,000 that are across the county, 81 are now, at least about 85 now, are currently certified. While pursuing my master's, I received an internship at the city of Gulfport, Mississippi. In regards to economic development, I actually worked on the project Cruising the Coast, where they actually had about a total of 7 beach towns, and over 3 days, each city held it for 3 days, where antique cars were held on the beach, and then they had festivals and things like that. It's a very good event to really highlight the community. And then also before that, I was with the Federation of Southern Cooperatives, where I work with cooperatives, helping them become 8A and Hub Zone certified, and I worked with across 14 different states. And then when I left, I was working with Vietnamese oyster farmers in Louisiana, helping them sell oysters overseas as well as black beans. And that's kind of the highlight, high profile of some of the things I work with. And my introduction to economic development was working with the FBI to deal with a beef processing facility issue in Mississippi.
That's fantastic. Any comments or questions?
Well, thanks for joining the team for sure. Thank you for being responsive. I'm really looking forward to working with you. Thanks for taking on some of these tasks that I, honestly, thought I might have to do and started to prepare to do. So thank you for helping alleviate some of that on that. Yeah, and I spent my second term at Biloxi at Keesler Air Force Base. So
Nice.
I don't envy you having to reside there for as long as you did. We call it the Keesler shovel with the humidity and the rains every day.
Yes.
So thank you again. Nice meeting you, sir.
You as well.
John?
No, yeah, I remember that there was something Indiana related on that resume, right?
I work with Purdue University.
Yeah, go Purdue. I was about 30 minutes away from Purdue before I moved down here. So welcome to the team. Very impressive resume, and glad to have you on the team.
Thank you.
Yes, I just want to say welcome, and this is an extremely impressive resume, and it's going to be an honor to work with you.
Absolutely. We've already had our meeting, setting the agendas and everything, and it's been a pleasure, and you've done so many things already, and look forward to even more as we move forward. So wonderful. Thank you so much. All right. Anything else? I have one thing. Since we voted on the minutes and approved the minutes, I have them here. I signed. I'm going to pass them over to the secretary to sign. And could you please go back into the previous minutes and pull those, because I don't believe those were ever signed. And I want to make sure that we are dotting our i's and crossing our t's. So if we could maybe pull those up from our previous meetings where we've approved so that I can sign them and our secretary can sign them also.
Sir, I have just a nuance of a comment, and I could be wrong, but for some reason, I think there is either a statutory mention in 159 that can we research whether we need to affix our seal to these official documents? I feel like I read that somewhere, that we had to affix the seal of the IDA.
I can confirm it, but.
Okay,
that's
thank
fine.
you, thank you.
Okay, good point. Yeah. Okay, with that, we have a community outreach section. Is there anyone in the community who would like to take the time to address the board in any action or comments? Okay, seeing there are none, we will move forward. We are board member comments. I'll start down there. Sean, any comments?
No further comment.
Thank you. Chad?
Yeah, just a couple things to add. Since we do have an applicant, I would like to, is it acceptable to discuss the applicant or where we're at in that at all? Or are we just in the early stages or?
We just needed to get the bylaws approved so we can get that submitted. So I wanted to make sure we had the fee in process because that is a non-refundable fee. So I want to make sure we had everything lined up. So once we receive that will not be returning that back to the applicant. So I was trying to make sure we had everything laid out properly and that we could expedite and be fair to the person that submitted the application.
Okay, very good. Thank you for that. So my understanding is, and just a little check mark for some homework for all of us, there is an inducement resolution or an inducement agreement that we can create with the applicant. And this document is usually used to circumvent some of the spending of the money or the funds ahead of the actual bond resolution being adopted. So just in doing some research on the IDRBs in the past, because this process can take usually a minimum of 12 weeks to actually get it towards past us, there is a lot of references in other agencies completing an inducement resolution, which I guess allows the applicant to essentially begin to spend some of the bond money as sort of the precursor to the bond coming before us. And there's specific legal requirements for the way that agreement or that inducement resolution is drafted. But I would like for us to have the process of that in the event we do have an applicant that's ready to go. We don't want them waiting on a land contract or something. And, I would like to refine that process if we could,
Yes.
please. All right. That's all I have, sir.
Thank you very much.
Mr.
Good
Chair,
point.
I can answer that question quickly.
Oh,
on regards to
perfect.
the seal.
Thank you.
So the statute just simply states that the secretary shall keep a record of the proceedings of the authority and shall be the custodian of all books and records of the authority and of its official seal. So
Okay,
then the
great.
requirement is that you're the custodian of the seal, not
Okay.
that the minutes have to be sealed.
Thank you for that, sir. Do you happen to know anything about the last question having to do with an inducement resolution or an inducement agreement for revenue bonds? Or can we follow up on that one?
Just follow up on that one.
Okay, will do.
Because I just send the question through staff and
Okay, will
I'll
do.
look into it.
Thank you, sir.
Thank you. Richard?
Nope, I'm good.
Good, thank you. My only comment is I appreciate all the hard work that the members have put in to get us all in line. And the commissioners have created this, we've been able to put forward the application and the process, which is vitally important. What I'd like to ask Michael and Juan, if we could review Section 159 and look back at what we've done so far with the bylaws and make sure that we've covered all our bases, like we talked about with the minutes, the seal, any other things that we need to do from a procedural aspect or a paper aspect, so that when we're finished, hopefully by the next meeting, we're off and running, that what we're doing is not procedural anymore, but we're sorting through applications, we're doing the work of the people, of creating an opportunity for growth and development within the county to where staff doesn't have to put a lot of work into it with the application, and then we can understand what that process is. And then we can start going out and letting the world know that we're open for business on that procedural and statutorial basis. Is that reasonable to think by next month we could look over that? And it may be done, and you might just go, we're good.
All right, that should be fine. I mean, I guess the best way is thinking, 159 gives you kind of a structural framework. However, the statute also provides that the statute is liberally construed in order for you to effectuate what you need to get done.
Gotcha.
So,
Okay, good. So then it's more of an administrative side then, so if we could just knock that out. We agree?
Yeah, I do have one comment though too, and something a little bit different. We've been talked about,
Your mic's not on.
I'm sorry. Yeah, we were gonna get a Zoom call, so if you couldn't attend for certain reasons, we could all connect in, even though we need a quorum here. But we were gonna have it by Zoom as well. Is anything happening on that front?
what happens, staff will have to coordinate with our IT department. I know that my understanding is, I know that the county commission had a policy that they did not have a allowing for remote attendance. However, that policy did not carry down to the rest of the boards. Now, that's just going to be practical application of how to get the machinery in to get for remote attendance. So, but it would require just sufficient lead time to coordinate with our IT department to get the proper equipment prepared in order to accept the Zoom call. Basically, connect that's beyond my pay grade. I went to law school, and I have no idea still how. I'm in that tween generation that I might look young, but I'm still old school. I still did law by books. So
My IT is calling for my wife. The thing is, we really do need to get that. I have some issues coming up, if you will, that may take me away for a little bit. So I'd like to be able to attend the meetings, and the only way to do that is via Zoom.
it's understood. And then for that, it's just going to be coordination with the IT department to get the to get that set up, to get ours would be done through Microsoft Teams. That's what the county uses for
Yep, that's
remote
fine.
meetings.
Good, all right. Any other business? Good. I will entertain a motion to adjourn.
I'll make a motion to adjourn, Mr. Chairman.
Chair?
Second.
Chad, second. Richard, all in favor?
Aye.
Anybody want to stay? There are none? We are adjourned. I know, I had a gavel.
No gavel. Well, might be one in the drawer.
There's one in the drawer.
There's one in the drawer, I bet. That's the special drawer.